I think it's fitting as the last speaker to return to the very beginning, to the very, very beginning. I'm talking about the Tadic case. So I'm going to return to Tadic today. I don't generally like to read presentations, but it will keep me focused and hopefully I can finish in time. So the establishment of the ICTY in 1993 and the subsequent establishment of the ICTR in 1995 ended an almost 50-year period of post-Nuremberg impunity and inaction for international crimes. We're all aware of this. The ad hoc international criminal tribunals were established amid great international fanfare, but the unprecedented, unconventional method of establishment by way of Security Council resolution raised foundational questions about the legitimacy of these institutions right from the start. Although, in the view of some, the Tadic Appeals Chamber judgment had the result of putting to rest some concerns relating to the legitimacy of the establishment by Security Council fiat, many academics and others remained uneasy about the question of the relevance of the Tadic question for the establishment, remained uneasy about the legitimacy of the tribunals. Since the arguments made by the Tadic Appeals Chamber has been replicated in trials such as the Saddam Hussein trial and the Charles Taylor trial, the question of the relevance of the Tadic judgment for the establishment of the ICTR and other so-called successor tribunals remain alive and relevant. And in this regard, I just thought I'd quote the American academic Jose Alvarez, who asked whether the Security Council can create a denationalized body capable of depriving individuals of their liberty without national court appeal or national court involvement. This was part of how he framed this question. Today I will focus on the question of whether the ICTR was legitimately established and the implications of this question for the legacy of the tribunal. It will be argued that the legacy of the ICTR cannot be disentangled from the question of the legitimacy of the tribunal. Discontent surrounding the establishment of the ICTR affects the legacy of the ICTR because it can be argued that a less than legitimately established court has to perform harder to compensate for the defect in the legitimacy of its creation, if it is possible to attain or acquire legitimacy at a later stage at all. So that is if you provide for the possibility that it's not a sort of a once and for all, or not a sort of it's not clear that if you don't have legitimacy right at your establishment that you can never acquire it later on. If you provide for that, then perhaps one can say that even that the tribunals can compensate for the initial defect in their legitimacy, or what I believe was an initial defect. In my paper that will hopefully be published, the debate around legitimacy as fleshed out by academics such as Yuval Shani and Armin van Bogdandi will be elaborated on further. I will broadly follow the legitimacy models conceptualized by Wayne Sandholz. I will argue that legitimacy is not an absolute quality and that the ICTR has over time acquired a measure of legitimacy. What is legitimacy? Now, Thomas Frank defined legitimacy as a property of a rule or rule-making institution which itself exerts a pull towards compliance to those addressed normatively. Legitimacy accommodates a deeply held popular belief that for a system of values to be fair, it must be rooted in a framework of formal requirements about how rules are made, interpreted, and applied. The aims of the ad hoc tribunals, those of serving peace, deterring future crimes, and advancing reconciliation, can only be achieved if the tribunals are perceived as legitimate. The severity of the sanctions imposed by criminal law, including life imprisonment in the case of the ad hoc tribunals, add weight to this argument or to the importance of legitimacy. Because of time constraints, I will not say much about the relationship between legitimacy and compliance or the relationship between legitimacy and legality. This will also be elaborated on in my written paper. I'll now move to the relevance of the Tadic case. Of course, those who opposed the establishment of the ICTY by the Security Council resolution argued that the tribunal should have been established by treaty, and others supported establishment by the General Assembly as the most representative political organ of the UN. The ICTY confronted the question of its legitimacy for the first time in the Tadic case, And as many of you know, the trial chamber concluded that the ICTY was a tribunal with a limited criminal jurisdiction derived solely from the statute, and that the tribunal did not have the jurisdiction to determine the legality of its own creation. The trial chamber held that the competence of the tribunal is narrowly defined and does not extend beyond prosecution. In contrast, the majority of the appeals chamber disagreed with the view of the trial chamber and held that the principle of competence in German gave the tribunal the jurisdiction to determine its own jurisdiction. The appeal chamber held that the inherent jurisdiction of the tribunal derived automatically from its judicial function. So, the appeals chamber did an extraordinary thing. The appeals chamber judges, of course, decided about their own legitimacy. So it was, of course, highly improbable that they would have decided themselves out of a job in essence. And this has been interestingly commented on by Muhammad Shabuddin, who was a judge at the time, who forcefully argued that the appeals chamber judges should simply never have been asked to decide this question, because a judge cannot wear those two hats at the same time, the hat of a judge as well as the hat of someone who has to assess whether the institution that has made him a judge is legitimate. Okay? But we have the Irish Appeals Chamber judgment now as the authority. So although the Appeals Chamber formally answered the question of legitimacy of the ICTY, many are of the view that the reasoning of the Appeals Chamber wasn't sufficiently strong or persuasive. The matter of the legality of the ICTY was again raised when Milosevic was first brought to stand trial, not before the ICTY but before the Hague District Court. Milosevic predictably argued that the tribunal should have been established by international convention or by the General Assembly, but not by Security Council. And this then became a sort of a stock defense used by many accused. In the context of the ICTR, the establishment by Security Council resolution was equally controversial, but did not receive as much scholarly attention as the Tadic case did. Of course, this is a general tendency that the ICTR didn't get as much scholarly attention as the ICTY. In Ntaki Rutimana, the legitimacy of the ICTR was challenged in a district court in the United States. So it's interesting, the legitimacy of the ICTR was initially challenged not before the ICTR, as in the case of the ICTY, but by a district court in the US. In this case, the US, on behalf of the ICTR, requested the extradition of Ntaki Rutimana. His counsel argued that the UN Security Council exceeded its power under Chapter 7 of the UN Charter in establishing the ICTR. He explained why the Tadic judgment did not settle the question of the legitimacy when the defense counsel said, the Tadic opinion adds nothing to this issue. The Yugoslavia Tribunal is a creature of the very statute that was under challenge. The several views of judges show that they cannot agree on anything but their own legitimacy, but they fail to find a source for their creation in the Charter. So the court made it clear that even though Tadic has settled the matter for the purposes of the ICTY, the merits of the case still had to be decided. The first legitimacy challenge brought by the ICTR was brought by Joseph Kanyabashi. Like the Tadic trial chamber, the Kanyabashi trial chamber rejected the defense challenges to the jurisdiction of the ICTR. But Kanyabashi was more than just a copy of Tadic. For purposes of brevity, I'm not going to go into the details of Kanyabashi, but it is interesting that it has different arguments than were raised in the Tadic case, and the judges did carefully go through those arguments and rejected the principal objections raised by the defense, such as the argument that the ICTR violated state sovereignty because it was not established by means of a treaty, but was imposed by the Security Council. Right, so I am going to skip quite a section and move to the Sandholz models of legitimacy. That was just by way of background, but I don't want to draw it out too much for today. So in the view of Wayne Sandholz, legitimacy is not a fixed immutable quality, but the legitimacy of international institutions can fluctuate over time. Importantly, he argues that institutions which initially lack legitimacy can acquire such legitimacy over time. Sandholz further proposes that different kinds of legitimacy characterize different phases of institutional life. When an international tribunal is first created, two kinds of legitimacy become relevant. Sandholz suggests that institutions acquire procedural legitimacy when they come into existence by procedures that are consistent with prevailing norms and standards. Purposive legitimacy implies that the purposes served by an institution are considered to be consistent with the broader values of international society. In Sandholz's legitimacy scheme, an institution that has been created outside the usual rules can still be considered legitimate if it serves the purpose that is widely seen as relevant and important. After the establishment of a new institution, the nature of the legitimacy gradually shifts or can shift. Performance legitimacy requires that the functioning of institutions can be seen as acceptably effective. So, in essence, Sandholz sets out various sort of forms of legitimacy. He also argues that tribunals can lose legitimacy if, in spite of legitimate establishment, they do not act in a way that shows that they deserve continued respect and compliance. Now, whereas the ICTR can be said to have questionable procedural legitimacy, that is my point of view, that the establishment by Security Council fiat was in a sense unusual and questionable. The ICTR have compensated for this defect in its creation by subsequently gaining performance and purposive legitimacy. As the years went by, the ICTR became increasingly effective. As the tribunal gained more access to financial and other resources, the tribunal's ability to effectively execute its mandate improved. So, just with regard to purposive legitimacy, what I wanted to say about the ICTR was that the fact that the ICTR never indicted any members of the RPF led to accusations of victim's justice. These accusations of one-sidedness, more than any other fact, led to the charge that the ICTR lacks legitimacy. And some have gone as far as to argue that the one-sidedness of the ICTR calls into question all its findings. It's often been said that a system of justice can only be effective if all parties recognize the legitimacy of the process. For this reason, it could be argued that it is questionable whether the work of the ICTR was consistent with the broader values of international society. And then I just want to mention that in my written paper I will address the legitimacy of the Gacaca courts. Here there's been arguments that the Gacaca courts to an extent lacked democratic legitimacy. It's an argument that stems from the lack of inclusivity and representativity of the Gacaca courts. It's frequently been said that the Gacaca courts derive their legitimacy from popular participation, but there's been arguments that it's still not democratic enough. But I think that's possibly an unfair argument. Okay, so in terms of a conclusion, I would say that the legitimacy of the ICTR is a foundational question, not just for the ICTR, but for successor tribunals, for the ICC, and for international criminal justice more widely. If the legitimacy of the ICTR is not established satisfactorily, it affects how one assesses the achievements of the ICTR. In the early years of the existence of the ICTY, Jose Alvarez wrote that the Tadic trial, of the ICTY, Alvarez wrote that the Tadic trial was foundational, political, and epic. He explained that the Tadic trial was foundational in that it sought to reinvigorate the Nuremberg principles and indirectly the rule of law, political in as far as it sought to deter future war crimes and make reconciliation in Yugoslavia possible, and epic, since that was at stake is the Security Council's power to direct the first international criminal proceedings since World War II through ad hoc tribunals established by the Security Council. The same reasoning applies to the establishment of the ICTR. Just as in the case of the ICTY, the ICTR had to reinvigorate the Nuremberg principles in the Great Lakes region. The achievement of the ICTR, as well as the legacy of the ICTR, will be diminished if the ICTR is ultimately found to have been illegitimately established. Along the reasoning of Sandholz, however, it is possible to argue that the ICTR has gained legitimacy over its lifetime, mostly because of its effectiveness in carrying out its mandate. In spite of the legitimate criticism against the ICTR with regard to victor's justice, the ICTR has developed international criminal law and, to an extent, helped realize the rule of law in Rwanda. For these and many other reasons, and it can be argued that the ICTR earned its legitimacy.